Good afternoon and welcome to the LPA webinar on the 5th AML Directive and other AML developments. Before we start, just a quick reminder that you can ask questions during our session via the Q&A button and also use the chat function. Peter, Chair of the AML Committee, will be our moderator and introduce you to our expert panel. They will start with the Luxembourg legal framework, discuss the implementation of the 5th Directive, the practical implications for our industry, and also look into CDD matters. In this context, I would also recommend you to have a look at our CEO's interview with Mr. Claude Marx, Director General of the CSSF, which once edited will be made available on our YouTube channel soon. Peter, the floor is yours.
Thank you very much, Stefan. Thanks everybody for joining. Very welcome. It's my pleasure to introduce the panel to you. It's a diverse lineup that we have here. First of all, ladies first, we have Stephanie Kastrik. And Stephanie is the Head of Regulatory and Compliance at IQ-EQ. And in addition, Stephanie also sits on a AML discussion group, which is headed by the CSSF. Next up, we have Christian Hertz. Christian Hertz used to be an M&A lawyer and a funds lawyer before moving to his current role as General Counsel at LIS. And finally, last but not least, we have Stefan Bade. And Stefan is a partner at Arendt, and Stefan advises Arendt's clients on everything and anything related to AML and KYC. And I'm Pieter Leguit, and I'm your moderator for this webinar. First of all, a question to you, Stefan. As a sort of introduction to the topic, could you perhaps give a general overview of the Luxembourg legal framework surrounding AML?
Thank you, Peter. Yes, so I think we took the choice to run you through over the last recent developments, which has been many, and the latest law of 30 March 2020 actually complete the package of the AML 4th Directive and AML 5th Directive. So you will see when we discuss that some gold plating has been done. So not only the legislator has taken the opportunity to implement the rules, but also some of the topics that were dear to their heart. So you remember that December 2017, we had a law that was actually anticipating some of the changes on the tax side. That was actually, for everyone to remind, followed up by the CSSF circular letter 17650. It's quite important one. So that was the initiation of the implementation of AML 4. That was followed up on February 2018, implementing what I would say the core elements of the AML 4. And then there were also a few other changes that happened in the course of August. And bear in mind that today, in the context of the LPA, we are talking to funds, to alternatives, but the actually AML 5 and 6 is a much broader package that was obviously covering a number of actors and not only fund managers. So after August 2018, if we follow up the line, we had a very important law of 13 January 2019 on the RDE. So the beneficial owner, which is really one of the elements which is on the core of this changing. You remember that all this change, all this European package was the result of the terrorist attack, but also some of the issues around Panama paper. And so, beneficial owner is really a central piece, central figure in this whole AML regulation. We also took the opportunity to go ahead, and actually some of the propositions under the law of 13 January 2019 were already anticipating on some of the provision of the AML 5th. So really the law of 25th of March is kind of completing this process. And we will see this in more detail now. And again, bearing in mind that very importantly, there was at the same time another law on central electronic data retrieval systems. And again, which is quite important when you consider the overall framework, but I will come to that in more detail. I'd like to say also very quickly that in the meantime, at European levels, there were some delegated regulations in terms of high-risk countries, and we see that this is very important for our purpose today. And also, follow up the publication of the law on January 2019. There was a very important circular from the CSF 19732 on some of the practical issues around RD. So all of these to be followed up. Now, don't forget, this is all of the new things, but you still have some circular which are applicable and you should take into consideration. Some circular on the risk assessment, the 11519 and 529, depending on which entity you are. The CSF regulation 1202, which should be changed or will certainly be changed in the coming months. And finally, the CSF circular 18698, which is mainly on the substance for management company, but has a strong component on AML. So with that, you have the overall regulatory legal package. And not to cover you up with the documentations, but if you want to read more, obviously you had also some industry guidelines, the FATF guidelines of October 2019 and the ESA guidelines, which I'm sure everyone has actually heard of. And that's probably where we are today in terms of the legal and regulatory package for, and again, for the funds, for the investment management industry.
Okay, thanks. Thank you, Stefan. That's a helpful overview. Christian, question to you. Does it mean that the 5th AML directive is now being fully implemented, or are there still some things that need to be done?
Yes, thanks, Peter. Well, indeed, the 5th directive is now almost entirely implemented, mainly in Luxembourg through last year UBO law and this year AML law. There are still some bits and pieces. For instance, at EU level, we are expecting a list of PEP. It's not a list of the physical persons who qualify as PEPs, but it will be a list of all the functions in each of the member states and in each of the international organizations present on soil the Union, the list of functions which are sufficiently prominent to qualify as PEP. So this is not yet implemented. It's provided by the 5th directive. It will be very useful, of course, for testing and for assessing who is a PEP. At Luxembourg level, we are also waiting for bits and pieces. The main one, I believe, is a register of trust, where we will have indications about the beneficial ownership relating to trust, so trustee, beneficiary, settler, and all the other beneficial ownership which are listed in the AML law and which will be present in this register, at least when the trustee is present in Luxembourg, or in certain other cases where there is a link to Luxembourg. So all in all, we are almost there, but we are not quite there.
Okay, thanks, good to know. In a bit of a broader context of recent AML developments, we've all seen and encountered a lot of questions about the requirement to actually appoint 2 people for the AML function. Stephanie, is there a bit more background that you can give us on that?
Yeah, indeed, the disappointment of 2 persons in charge of AML CFT comes from the FAQ, which was published in November 2019. So there has been a lot of discussion about that, but the CSSF has clarified the need to appoint 2 persons instead of 1 previously stated, so in charge of AML and CFT. So this FAQ has details some some conditions and the way it should be organized. And the methodology, in fact, the background document they use for that is the national risk assessment. So there was in the next slide please, you will see the national risk assessment that assess the inherent risk for collective investment funds as high. So collective investment being high, it's by nature a high risk. So it gets the collective funds has an inherent risk to be considered for all the risk assessments for those entities supervised by CSSF. So mainly we talk about the CIF, the TICAR, the authorized AIFM, the registered AIFM, and they also published, because you have also in the next slide, so the CSSF has published a breakdown of the inherent AML risk per subsector in the collective investments. So that gives really an assessment of our own entity, about our own structure, and to see what can be assessed, mitigate, and then get a residual risk on all of them. So this appointment was mandatory is mandatory actually for all the CSSF supervised entity, supervised and regulated entities. So we do not forget the registered IFM, which are sub-threshold but still supervised by the CSSF.
Very good. On those two officers that you have something called the RR and the RC. Can you tell us a bit more about that, and how do you what is the distinction?
Yeah, the appointment of the RR. So RR is, so in French, responsable du contrôle, du respect, responsable du respect des obligations. So it's responsible, the ultimate responsible for compliance of the professional AML CFT obligations. So, and the RC is the day-to-day management person who will be dealing with the AML CFT obligations and make sure that everything is in line with the obligations and with the law. So it will be more the escalation point for the operational teams. And in this FAQ, they have submitted more clarification, and the fact that the RR can be also the board of members or of directors or managers as collectively responsible for this. Whereas the RC can be a board member, but also can be delegated, this function can be delegated to a third party, so a provider or service provider, but must be specifically appointed, I mean, namely appointed and approved by the board collectively. So these are the two differences between RR and RC, and the RC should report to the RR. And so the next slide, you will see the difference, the main difference from the knowledge perspective. The main difference, so of course they need all to have the same sufficient knowledge, be knowledgeable about the investment and be available without any delay. But the RC is the person who will be not necessarily located in Luxembourg. It can be outside Luxembourg, but he needs to have access to all the internal documents and required to perform his duties and to draft, for example, the AML report, or to do the oversight due diligence on the delegates. So this is the main difference, because for performing his duties, he needs to get access to everything that is useful for this report.
Okay, and to what extent are these requirements actually really new, Stephanie?
It's not really new, because the FAQ focus on the Article 4 of the AML law, and the AML law already appointed, it was a request to appoint a compliance AML CFT compliance officer. And so if we can focus on this article on the next slide, and you will see that there is this consideration of the appointment of RR and RC. So they added the fact that, so it's in French, sorry, because in English we had not the version as of today, but they added the notion of money laundering and terrorist financing. And the CSSF has considered that this risk related to AML and CFT were high. So as they are high, you need to appoint 2 persons and in charge of compliance. So RR and RC, which are French abbreviation, but it is typically the way they should act. It's really the practice that they should now follow.
Okay, clear. And just to be very clear on this, do you always need to appoint 2 persons, an RR and an RC, or does it depend on your status or the circumstances? What is the current thinking on that?
There is a lot of discussions in the market because yes, so for the regulated world, the CIF, the CCR regulated, for all the regulated and supervised entities by CSSF, it's clear. They need to appoint 2 persons in charge of compliance, so RR and RC. For the non-regulated funds or investment fund manager, there is some discussion because they are not under CSSF supervision, they are under AED supervision, Administration des enregistrements et des domaines. And some claim that it could be only the appointment of 1 person, but the market practice and best practice to follow the same guidelines as in the regulated world. So if some clients would do so, we would recommend to really document it and to make maybe an assessment or to get an advice from the lawyers, because the practice and the best practice is to really follow these guidelines in the market. So that would be, but it is there is some discussions indeed. It's not crystal clear for all non-regulated funds.
Okay, that's good to know. Back to the topic of AMLD 5 in particular, Stefan, a question for you. What are the most notable changes when you compare AMLD 5 to the rules that were previously enforced?
Thank you, Peter. Well, as I mentioned, I think this needs to be seen as a global package. So there are obviously a few changes which actually may have an impact with us, because some of the actors that previously were not within the scope are now. So typically real estate agents, virtual assets, and currency. So you can have a connection there with the alternative world. And there were other, but the main idea was reinforcement of CDD measures applicable to professionals, and including some new enhanced due diligence rules and measures. And we talk in further detail, I think, of various countries. There's also some review on the use of third party and the third-party introducer, which may not be super used in the market, but I think it's it's quite important to mention. There's also some reinforcement and alignment in terms of regulatory bodies and your self-regulatory bodies. And I think this is all this piece of the regulations that will not impact our community directly, but are very important for a global AML fight. So, coordinations and strengthening of the national and international cooperations, this alignment of power between, for example, the Institut des réviseurs d'entreprise, the lawyers, the bar associations. So, all of these come from the law with really this objective to have alignment, reinforcement, and again, bearing in mind that all of this was done in the context of the fight against terrorism and the lessons we had following the terrorist attacks which had plagued Europe 2 or 3 years ago. So these are some of the main things. Now, as I said, NSCDD, we have further more detailed provision in respect of the UBO, and particularly when you are in the context of control. Some clarifications on how this control should be detailed. You remember that the way we assess BOs are either through looking for the 25% holding of the chain, so directly or indirectly, and then we had these provisions on moving to someone that would control by other means the company. And here the law comes with some additional elements to help us in terms of doing that. So there are a bit more precisions in terms of the nature of these officials, what does it mean, and how this beneficial owner through control can be identified. There's another point also I'd like to mention, because I think it's quite important. It's important for us in the alternative, the question of proxies. As you know, anyone representing the company needs also to be identified. And there's a relatively strict provision that comes out from the 1202, which requires really the knowledge and the identification and verification of that proxy, which sometimes creates issues when you have an institutions where you can you deal with your client and you have a board member in front of you, which is the proxy of the company. But in the context of the execution of the orders, you may have other people representing the company. And because of that strict applications, sometimes we see a necessity to re-identify this person and collect again KYC and so on and so forth, which sometimes has created some issue, particularly between the regulated firms. So that, which was in the 1202, and that's part of the gold plating I was mentioning before, has now been put in the law. So there's not much escape in terms of proxies. People will have to be careful that they are duly identified and verification of their ID are duly done.
Thank you. Christian, question for you. What do you view as the most practical implications for the private equity industry?
Yes, so if I have to pick one, maybe I would speak about the definition of UBO. So the clarification that has been inserted on which are the cases where control by other means has to be considered when you identify UBOs, and this is important because it applies, of course, as much to the future transactions and setup and to the existing one, and you may need to revisit certain of the UBO identifications that you have done. The impact is at least at 3 levels. So at the level of the fund itself, so who are the UBOs of the structure, the impact as well at investors level, so the LPs, and potential impact at investments level. So first at the level of the structure itself, the clarifications, again, arguably, it's just clarification, and some may have applied exactly the same rules before, but now it's explicit. If you have a GP where no physical person holds directly or indirectly at least 25% in equity, you can no longer, if you could before, automatically move to the management as being the UBOs. You need to look at as to whether there is a physical person behind the UBO and beyond equity holdings who is actually driving and controlling the GP, even if the equity is held by a Stichting or whoever. So that's on the structure itself. Who are the UBOs of the structure of the GP? Now, on the LP side, on the investor side, of course, you need to check who are the investors and the ultimate beneficial owners of the investor. And here the same applies. From a practical perspective, hopefully the existing subscription agreements were large enough not to need to change them, but certainly for the future, a clarification and an alignment to the definition, the new definition in the law is recommendable. And thirdly, on the investment side, of course, the identification of the beneficial owners also applies to the counterparty check that you need to conduct before you do a transactions, acquisitions, or a cession of assets, but also the other main counterparties you may have in a fund. Then here again, the good recommendation is maybe not to change the investment advisory agreements and portfolio management agreements that are in place, but certainly to specify in the operating memoranda that you have with portfolio managers and investment advisors, to specify there the new definition of UBO, the extended definition of UBO, I would say, regarding who you need to check when you do your counterparty checks. So there are other impacts, of course, and Stefan just mentioned a number of them, but this is the one I would pick if you ask me one.
Very good, thanks. That sort of brings us to the topic of customer due diligence. Stefan, in that respect, what are the changes that AMLD 5 brings us on the topic of customer due diligence?
I think AML4 was already bringing quite a lot of changes in terms of the CDD. Now, what we can see with AML5 is, this documentation obligations and the verification of the process, which is emphasized. And actually, there's an interesting point, which is that you need to document the fact that you had difficulty potentially collecting the documentation on your customer. There's also some specific elements and clarifications around trust and financial arrangement. Don't forget that under the previous change, and it was very important change for the trust side, that in the trust, almost every participant to the trust is considered as a beneficial owner. So you're the guarantor, the settler, the trustee himself, and obviously the beneficiary if they are any. So it's not major change, but these are changes that just foster, continue to bang on the head of documenting your KYC, making sure that you have everything that you need, and if you fail or if you are difficulty, then you need to mention it. Also, they have added one of the requirements, which is that when contracted with an entity which is subject to RDO registrations, you need to collect the proof thereof, which is interesting because it was quite clear that the RDE cannot be your KYC, meaning that you need to do your KYC, and then once you've done that, you've done your own process, you can confirm the information you've collected through the RDE, which actually may bring some interesting situations, because in this world of understanding the setup, and as Christian mentioned, there are some rules. There's actually some very legal interpretations. We may end up with different views on who's the VO in a firm or in a fund. There is obviously something which is very interesting, because for once, this is not prescriptive, but this is opening the door for more flexibility, is the integration of digital ID. So not any digital ID, it has to be agreed under EU regulations, but that would be recognized as a source which is independent and reliable, which is really our key elements when we do a KYC, ensuring independency of the source and the reliability of the documentation. So that is certainly a welcome addition to the Luxembourg regulatory toolbox. And this is actually a timely change because FATF released in March its guideline around digital identity. So, it's interesting to see that the guidelines, for example, they see the growth of digital payment, and actually I think they made the figures that it is estimated 60% of the world GDP which will be digitalized. So the transaction through digitalized means is going to be enormous, and there is no doubt it's going to affect us even on the alternative business. So now there's one slight issue with that, or two. There's a technical one, which is that it has to be EU recognized, so you need to base yourself on technology which will have been approved at the EU level by the EU regulations 910/2014. But also it's only talking about individuals, natural persons. So we are not still into, I think, what we all dream of, which would be doing digitalized KYC for corporate, for entity. There are many solutions in the market. There are some working group in Luxembourg to push this kind of solution, and I'm very hopeful that this is the first step to go further and have this go forward. So, this is obviously something that needs to be taken into consideration, and potentially will be integrated in the coming months into the setup of the TAs and all the service providers which are doing KYC now. So that's one of the additions that at least is a really positive point, and does not put more pressure, but may open some new doors for KYC requirements.
Okay, thank you. Christian, question for you on the topic of enhanced customer due diligence. When do you need to do that under these new rules?
Yeah, so the changes which have been introduced by the implementation of AML5 directive regarding as to when you need to do your enhanced due diligence relate to vary depending on what has really triggered the requirement to do enhanced due diligence. Okay, so if you have to do enhanced due diligence because you are in business relationships with high-risk countries, then obviously you need to adapt the rhythm and the timing of your enhanced due diligence or renewal of your enhanced due diligence checks, depending as to when the high-risk country lists are amended. And Stefan Badley alluded to it earlier. It's worth noting that the EU has adopted on the 7th of May, so 2 weeks ago, an updated high-risk country regulation. So because of COVID, the new countries to be considered, to be added to the list will only be effective 1st of October, which gives a bit of time. The countries which are withdrawn from the list, that's quicker because the EU wanted to be nicer to these countries. So it will be 20 days after publication of the regulation. But of course, this has an impact, practical impact for the PE industry, not only to adapt the policies and the lists, but also potentially to adapt, as I said for the previous question, the operating memoranda, notably with the advisors and portfolio managers when they conduct their counterparty checks. That's what I wanted to say about the frequency or the timing for enhanced due diligence, which is linked to high-risk countries. Now, if you are doing enhanced due diligence because not of the country, but because of the person you are interacting with, because this person qualifies as a PEP, as a politically exposed person. Here, there has been a change. I would say a small change, but still, it changes the lines of the rules. Before, in the definition, you had the principle that after 1 year after leaving the prominent function which made the person qualifying as a PEP, this person would no longer qualify as a PEP. Now, this assumption has been deleted, and it's the contrary. You need to keep this person under monitoring for at least 12 months, but you may have to do more, and you have to do more until only that person is considered on a risk-based approach as no longer specifically risky. Arguably, this was already the case before, but it's been made much clearer today.
Thank you, Christian. Stefan, question for you, because Christian mentioned the high-risk countries. When you do your enhanced customer due diligence on clients in high-risk countries, what does that consist of? Stefan, you're still on mute.
I would do this, guys. So that was someone had to do it, and it will be me. Just before jumping on that question, I think on the high risk on the EDD measure, there's one thing I believe is of interest, which is on the complex and unusual transactions, because the AML Fit brings or specify the concept. And particularly, they give 4 criteria, which is complex transactions, transactions with unusually high amounts, which have been operated on unusual manner, or which do not have an apparent economic or legal purpose. And any of these elements which bring you to an EDD. So that's quite kind of a change compared to what we used to have in the past, and I think it's quite important to know. And indeed, in the same idea, there's been clarification for the high-risk countries. So the first one, which in my view is really important, is, as you all know, when you do your risk classification, this is something that normally every firm will do, taking into account a number of elements. And you go and find some sources. It can be through a tool, but you can use the FME, you can use Transparency International, you can use the OECD ratings, you can use some US-based information, and obviously you're going to look at the FATF, the EU regulations, and you will somehow build your risk assessment, which means that between firms you may have a different view. It's one of the topics which is very biased. It depends where you sit, and the risk assessment may be really different depending on where you are, European firms, US firm, or Asian firms. So that was the whole idea. I think what the law has done now is that it imposed on us that when a country appears on the list of high-risk countries identified, designated as high-risk by either the EU, the FATF, or the CSSF, then we have to consider this is high-risk. There's no going around. And so that's obviously something that would slightly modify and impair the way we're doing it before. Now that's in theory. In practice, when you look at the list today, most of the countries, 90% of the fund industry would say these were high risk anyway. But that's still something that needs to be bear in mind, that when the countries are on this list, then it is high risk. Now, on the top of that, indeed, the law has given some additional measures that need to be carried out by the professional. And it's always the same idea, right? It's more information. So more information on the customer, on the beneficial owners, additional information on the intended nature of the business, on the source of funds, on the wealth of the customer and the BOs, the intended nature of the transactions, the information of the senior management of the clients coming from a high-risk countries, the understanding, a better understanding of the business relationship, and also obviously more monitoring on the transactions and the patterns linked to these transactions linked to this account. So the problem we have today is that additional information compared to what you had before. So it depends on where you were standing in terms of your own enhanced due diligence measures facing with high-risk countries. But certainly, I would advise any compliance officer today or people in the KYC to review this process and make sure that they are brought to a level which would be accepted by the regulator. And maybe a final point I'd like to mention is that the directive and also the law also provide measures for the national competent authority. So, national competent authority could take themselves some additional measure versus this high-risk country, which, for example, could be refusing establishment of a branch of a Luxembourg-based company into a country, or up to a point where you could say no business with that country. So today, this has been stated as an opportunity for the national competent authority to do it. We haven't heard from the CSF or anyone that actually this would be used. And bear in mind that if you want to push these measures, they have to be notified to the European Commission prior to their implementation. So, and again, all of this coming from the issues we had 4 or 5 years ago. I mean, a clear focus on high-risk countries, and certainly a bit of work for everyone here, particularly in the alternative where, as Christian mentioned, not only on the investor side, but also on the investment side. There you might have some exposure.
Great, thank you. Stephanie, question for you. When you do your customer due diligence, can you still rely on third parties?
Yeah, I would say the answer is yes. You can still rely on third party, but you need to make sure that now that the customer due diligence and that this provider or this third party has the same standards as we have in the AML law. So you need to ensure, of course, that it meets still the same criteria as per our law. It's still prohibited from using third party. That is not a change in the AML law. And so let's switch to the other side, the next one. And so the main change is that you need to take now appropriate measures to ensure that the provider, the third party, provides you all the data, information about CDD, etc. Upon request, sorry, but without any delay. And that is mandatory to be able to trust the third party, because there is no, it's already written in the law, but you cannot rely and they cannot argue there is a confidentiality aspect. So they need to provide you all the data you are requesting. And the next obligation now is to ensure that your entity is not under AML investigation. So there is not AML measures against that entity. So you still have now the obligation of checking that and make sure that the CDD, the customer due diligence standards, and the record keeping of the documents are the same as the ones we have in the AML law. So yeah, you just need to make to do some safekeepers and put additional measures on them.
Okay, thank you. Stefan, this AMLD 5, does it require people to make any changes to their internal organization?
No strong changes. Stephanie mentioned obviously the RC, which is a strong component. We still have the AML independent audit functions also, which is subject to a proportionality basis. But I think what the law says very clearly, and I think this is also the result of what our regulators find out when doing their on-site visit, is that these functions need to be properly resourced, need to have the proper means, and Stephanie made the allusions to that early on, that they have to have the right resource, they have to be given the access to the informations and the tools so that they can conduct their missions without any restraints. And obviously, there's notions of being independent. So I think it was mostly already there, but this is just something that came in addition with this reinforcement that as an RC or an AML compliance officer, you need to have access to the board or to the executive committee, depending on the way you are set up, without having someone hierarchical on top of you. So that's that goes also around all these rules around whistleblowing. So that's something that has been put more clearly within the law. The other one also I found interesting is in terms of training. We are very much customized in Luxembourg to do training. We do training on a yearly basis. I think the message here is that you need to do training, but it has to be specific. And with clear explanation of all aspects of the anti-money laundering, anti-terrorist financing laws, including duties and vigilance towards customer and suspicious transaction. And we've seen this from CSF against visit. It has to be specific. So you should not get into something where employees will do exactly the same high-level training every day, and it must be adapted to obviously where you stand in the organizations and how much you are concerned with AML. So a compliance officer is not going to have the same training as a sales guy. So that's the kind of idea that we can see underlying this requirement. And the final one, there's a whole sections on group policy. So obviously when you have subsidiaries and the reasons why we have this in the law, as you may all be aware, is some of our Nordic friends had some issue with their subsidiaries where they were supposed to abide to group regulations, but took some liberty and they had some AML scandal. So that's what the requirement here is, that your rules applying to your subsidiaries or to the company within the group has to comply with the Luxembourg structure, and you have to make sure that this is enforced, and there's no doubt that this is being carried out. So if any of our audience today you have subsidiaries, that's the time to review this. And another point also, which I think is coming out again, which is again not very new, but there's a bit more than that, it's on the risk assessment. I think we collectively as Luxembourg have been failing on the risk assessment piece, and the risk assessment is due for every single institution which is falling under the covers of the law. So almost everyone now, particularly in the fund industry, almost every manager will have to do this. And so there are specific circular, I mentioned them before, which clearly states the way you should do it, restated within the law. One of the elements that Stephanie mentioned is that risk assessment then needs to take into consideration the national risk assessment. So you need to embed that information into your risk assessment and take into consideration this when you do your risk assessment. And why also risk assessment is particularly important now in this period of COVID, because CSSF has issued a circular about 2 weeks ago, I'm kind of losing time now, the 2750, and they list down some of these elements linked to today, some of these threats that could be harmful to your business, and invite everyone to actually review this from an AML perspective. But believe me, I think this is valid for any type of business. But from an AML perspective, this is a review that should be performed. So again, this is something that we need to be done and not directly linked to the AML FIF, but deeply into the new AML development.
Thanks very much, Stefan. That's very good to know. These were the questions that we sort of had prepared for each other, but there's also questions from our attendees, from our audience participants. I would like to encourage people following this to keep questions coming in. Right now we have 4, which I would all like to place at the doorstep of Christian. Christian, the first one is a question whether you can clarify what the difference is between an inherent risk and a residual risk.
Yes. Yes. So thanks for the anonymous attendee to ask the question, for asking the question, because indeed these concepts originally were also question marks on our side. So the inherent risk is the risk that exist because of the situation. So the inherent risk of a fund investing in high-risk countries is the fact that it invests in high-risk countries. Now, you need to describe this risk in your AML procedures of the fund. What is the inherent risks that the fund is exposed to? So you explain this. And then you explain the mitigation measures that you have put in place so that the AML risk that is has been highlighted and also scored as being inherent, how you mitigate them. And hopefully the mitigation measures will end up with a residual risk, which is lower than the inherent risk of the situation you had at the beginning. And you will also rate it. So hopefully, if you had an inherent risk, which was high, it ends up being medium or low after the appropriate mitigation measures you've put in place. And that's what you need to disclose in your AML procedures. And that's what the RC is supposed to report also on an annual basis, whether this rating of the inherent risk and residual risk remains appropriate, and if not, whether there are additional mitigation measures which should be put in place.
Very good. Another question is about the RR and the RC. So the question there is, do these appointments need to be notified or even approved by the CSSF? And if so, for which entities do we need to do this?
Yeah, I think if we answer for the funds, I think it's quite straightforward. So the RC and RR have to be notified and approved by the CSSF for the regulated funds, and they don't need to be notified and approved by the CSSF for the non-regulated AIFs. With all the discussion that Stephanie presented before as to which situations we need to have any for the non-regulated ones, where the recommendation and best practice is to have for both.
And I would add also, if you want to set up now a new fund, you need to fill in the market entry form, and it's now required by the CSSF. So for the regulated funds. So you
for
need
the regulated ones, yes.
Yeah, exactly. So and for all of them now, they ask also in the annual survey that was to be submitted in April this year. They ask now the name of the compliance officer or RR and RC, both names now. Whereas last year it was not in place, so they only ask for the AML safety compliance officer name, just as additional information.
Okay. There was another question to clarify what we said on the RR. May this be a board member? Must it be a board member? Or is it good or best practice for the RR to be a board member? Christian?
Yeah, I think here the RR, so the RR, the practice and accepted by CSSF is really that usually the RR is collectively the board. Of course, it's not obligatory, and there are a number of RR who are individuals, and these individuals can be board members. But I think the practice is clearly in the direction that the RR is collectively the board. And I think it is a good practice because the board is ultimately responsible for everything. And if the RR is not the board collectively, then the RR has to report to the board as well. And then you end up in a 3 layers situation, whereas probably moving from a 1-layer situation to a 2-layer situation is sufficient and no need to have a 3rd layer. So I think the good practice and appropriate and market practice is to have RR as collectively the board.
Very good. Another question which
Peter, yeah, if I can just add on that, I think you completely agree with Christian, and one additional reason is we can see that the RC, the way this is built up, it's really a mandate that is given with a clear framework of the task, where the RR liability is a bit more diffuse. So indeed, aggregating this with the overall responsibility of the board is probably the safer route. So there's the join between the practice and the legal views.
Okay, thanks for that, Stefan. The 4th question that we have, I'll read it out. What is the expected role from the RC at a regulated fund level managed by an AFM versus the role of the appointed AML CFT compliance officer at the AFM, which is already responsible for performing AML CFT activity on behalf of the fund, conform 18698?
I think it's also a very good question because it gives the occasion to kill some myths in the market, I believe. So I don't think the difference would be here between a regulated fund and a non-regulated fund. So the same applies whether a regulated or non-regulated fund has appointed a licensed AIFM. And then the question, I read it, is why do we need basically an RC at the level of the fund, being regulated or not, whereas we already have a compliance officer at the level of the AFM? And I believe the roles are completely different. The primary role of the compliance officer of the AIFM is to make sure that the AIFM obligations are carried out in compliance with AML law and is not to ensure in details the AML checks at each and every of the funds which the AIFM has been appointed for. So for instance, the AML CTF officer of the AIFM is not doing an annual report to the board of each and every of the fund which have appointed the AIFM. That will be done by the RC of the relevant fund. The same goes, for instance, for registration with GoAML for declarations to the FIU. The AIFM compliance officer may have to do declarations with the FIU if they see something which is wrong in one of the funds they are appointed as AIFM, but will be done on behalf and in the name of the AIFM, not on behalf and in the name of the fund, unless the RC of the AFM has also been appointed as RC for the relevant fund, but that's a decision of the governing body of the relevant fund. It's not a decision of the AIFM in its own.
Yeah, and may I add something? I do agree with you, Christian, and it's very important because some clients may make some confusion between this role of compliance officer at the AIFM level and at their GP level, which is not the same. They need to appoint also someone at their level, at the GP level, the general partner level, and it's confusing for sometimes for them because they think that the AFM will be performing the duties of the compliance officer of the fund. So that is very important to raise it out because it's different and mainly also for the GoAML registration because each entity in Luxembourg needs to have its own access to Go AML, and some, as of today, still don't have. So that is also important to raise.
Thank you. Thanks, Stephanie. We have one last question, and that's also the only question we still have time for. And that's the question whether you can clarify the risk status of the Cayman Islands. Stefan, question for you, because they've been blacklisted recently. Should they only be sort of upgraded from medium to high risk if there are tax issues?
Well, for now, compared to what I've said earlier on, they are not on any EU list from an AML CFT perspective. So you're right, you need to take this into consideration in your overall risk assessment. But for now, Cayman Islands would fall into the category of countries where you take a number of things into consideration and you make your own risk assessment in relation to with Cayman Islands. So it will depend on everyone's view. Again, I believe US firms will potentially have a tendency to think that Cayman Islands is still a medium, despite the views on the tax, where potentially a European actor will consider this is higher risk because of a number of tax constraints that apply to us with CRS and all these things. So, but as for now, they are not to be obviously considered as high risk from an AML safety point of view. Directly.
Thanks. Thanks very much. Thanks to everybody. Back to you, Stefan Pesch from the LPEA for the closing remarks.
Thank you. Dear panel, thanks again for your insights, your involvement and hard work. Thank you everybody for attending today. And if you're not yet an LPA member and interested to join our association or committees, please contact us. Have a wonderful weekend and hope to see you next Tuesday for our webinar on valuations in COVID-19 times. Goodbye.